Myself. Commonwealth versus John Beatty. John Beatty. Are you John Beatty?
Yes.
Morning. Born 2000.
Yes.
Last four digits of your social security number 8125.
Yes.
What's Commonwealth have to say?
That family plan? Yes.
As you've heard, a motion has been made that says you wish to enter a plea today. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
No.
Freely, voluntarily given?
Yeah.
You're the same person we just identified in 25 CR 0005.
Yes.
Is your judgment impaired today?
No way.
Is your judgment impaired?
No.
You know what's going on?
Yes.
Okay. Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yeah.
Have you viewed the evidence Commonwealth has against you? Do you believe you're fully informed about your case?
Yeah.
You understand that you do not have to enter a guilty plea today. You have certain rights in the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go down through them at the end. I'm going to ask you to understand, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial with jury. I can be represented by counsel at your jury trial. Right to confirm the right to all witnesses called testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. Right to require a Commonwealth prove on a reasonable doubt that you're guilty of charges. You understand by entering a guilty plea today, you give up all those rights.
Yeah.
Understand that? Now, I may consider Commonwealth's recommendation, but I may apply a range of sentence provided below. I don't have to accept your recommendation. Prior to accepting the recommendation, I'll have a pre-sentence investigation report done by probation and parole. In the event that I do not accept the recommendation, after reviewing that report and decide to impose a harsher sentence, you have the right to withdraw your plea at that time and proceed to trial. You move to your left a little bit. Mr. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to trafficking in a controlled substance, first degree, first offense, the defendant shall receive a sentence of 10 years, serve 180 days in jail with the balance probated for 5 years supervised. The defendant shall receive credit for time served, but shall not be released from incarceration prior to final sentencing if he has served the 180 days in jail. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service until gainful employment is obtained. That would be per week. The defendant agrees to have any and all evidence in the above style case disposed of in accordance with the laws of the Commonwealth withholding agency.
Is that what you agreed to, sir? Is that what you agreed to? Are you pleading guilty because you did commit the acts charged in the indictment?
Yes.
You sued your own free will.
Yeah.
Under constitutional rights, it explains to your desire to enter this plea and allow the court to fix your punishment within the range of commit the law.
Yeah.
You understand that after entering this plea, you'd be a convicted felon, and any future convictions would be enhanced as far as range of penalty. You understand that?
Yeah.
Is that your signature on there?
Yes, it is.
Yeah, I'll accept the plea and schedule sentencing on August 7th. Thank you. Justin Daly. What? Did we send him a notice today? What do you have on him?
We were gonna get a trial date. We can pass it. He's a state prisoner, so we can come back next month and get.
Okay, we'll make sure we have a transportation order that up. Okay. Brandon Hall.
Yeah. That's good.
Commonwealth versus Brandon Hall, 25 CR 0039. Are you Brandon Hall?
Yes, sir.
Good morning. Are you born in 1982?
Yes, sir.
Last four digits, social security number 3773.
Yes, sir.
What does the Commonwealth have to say about this? You want to step to your left here, Mr. Stockton?
We need a trial date, Your Honor.
What's the charge here?
It's trafficking controlled substance first degree. He possessed 30 grams of methamphetamine.
Justin Bailey on the previous one, a transport order was even.
Who was supposed to transfer? Who was supposed to transport?
And he's state there's.
I'll have Mr. Green, if he steps back in the power.
Yeah.
It says tomorrow, the meeting,
Do what?
said on a bill meeting. We held for rural clerical office.
Zoom? Well, then we need to contact.
Well, yes, but then I realized there's a transport order that was here. I'm going on court next year, having the rotor transport yesterday on the second day of July, 2065, circuit court.
What are you looking at?
You'd be in that hand.
Show it to her.
Those are the order of hearings, Christmas that I do for Zoom, and then I received a transport order. Having transport.
Probation.
Okay. Did y'all mediate this, or did you make the offer on this?
Offer, he's got a traffic control substance first degree and PFO first degree. So he's convicted of the C felony, the PFO first, without any flat over. Offer 12 years at 20%, and that was projected, so I'll be ready for the
So he can go up to 20 years.
well, the C felony, yeah, at least, didn't have any flat over.
You inform him.
Yes.
Okay. Wednesdays are usually a good day here, right? They don't report them Wednesdays.
And this is the last one.
Yeah, so the 30th would be the last Wednesday of the month, right? You have a court hearing that day, is that right? Yeah. What about August the 1st?
Your Honor, would you go back and go to August?
Yeah, I can.
From the 30th.
Yeah,
or 10th,
Yeah.
or if you even want to set it over the prosecutor's conference, yeah, I'll go.
Now you might change your minds.
I have those 2 weeks blocked off at your office requested no jobs, requested the local.
Oh. Well, I'll figure it out, this, I've got Mr. Hunter and Miss Anderson, you don't know those days.
I just made a note on my calendar.
It's scary, it's like,
We're not involved in local cases the next week, right?
Yes, but,
Yeah, I got you.
I'll start.
How about August the 5th, a Tuesday? Y'all have a court here on Tuesday? Let's forget that. 12. Staying on 12 also.
Back to them with it.
See, the problem we got is if we have on Wednesdays, we take the public defender out of Cumberland, you know, and if we have it on most Thursdays, we got rule day somewhere, and then 12, they have district court here, so we got, you know, facilities problems. This, it's okay. I mean, it has nothing to do with you. It has to do with the facilities, you know.
They won't have this problem.
Yeah. From your lips to the Lord's ears. That's your possibility.
He said, yeah, I'm sorry.
I'm at the Carver house. First in.
One month, first, second week, second.
No, I'm still looking at August today. What did you say about the 11th? You be back?
I should be back.
Well, let's set this one 11th, okay?
The 11th works for me, so.
Okay. Just pay it, sounds like. Might have head lag.
Okay.
Thank you.
Nicholas Kaboo. How do you say that? Kuba. Nicholas Kuba, 25 CR 0034. Are you Nicholas Kuba? Yes, sir. Good morning. You born in 1988? Last four digits, social security number 8854. Correct. We're on a pretrial conference. Ms. Comwell.
I don't know, we discussed this case, is there a resolution or not?
If I can just get one more negotiation day, I'm working.
But it's got a case on another candidate.
Yes, yeah.
What is the negotiation day?
Be August the first.
Yeah, we be here August 1st for negotiation. And the next court date's August 7th. Both of them conditions your bond. Okay, Matthew May.
Thank you.
Yeah. Matthew May. Comwell versus Matthew May. Are you Matthew May? Yes, sir. Good morning. This is 25 CR 0048 and 21 CR 0014, which is a probation revocation. Were you born in 1987?
Yes, sir.
Last four digits social security 0653.
Yes, sir.
Let's go back there and tell them the key in the mic. Great. There's a room back there available that y'all can shout in. So, what does the comment have to say as far as Matthew May?
Well, we have a motion to revoke in 21 CR 14 and a new case 25 CR 48, which is fleeing and evading first handgun to convicted felon. So if we don't work out a global settlement, I'll be getting the trial date on that.
Well, have you had a negotiation day yet?
We have, I don't know what the status of this is.
Yeah, this is another one, if we could get another negotiation day, or we might be able to.
Well, we're not gonna start doing that, okay?
I mean,
We had negotiation day and this gentleman's fully informed. He's got a right to have a trial, so if he wants a trial. So I'm not going to start just putting stuff off. That's how you document, as they say in Monroe County, gummed up. So if he didn't have an agreement, then we'll set a trial date.
We'll set a trial date then, you're on.
How about the 18th
Of what?
August?
Yeah, that'd be fine.
Yes, that works for me as well, Ron. Thanks, sir.
Jody, we got a Monroe County case here, Jody Murphy. Oh. Low. Beautiful drive over.
It was.
Yeah.
Try to get hold of that.
Commonwealth versus Jody Murphy. This is Monroe Circuit Court meeting in special session in Albany, Kentucky. This is 24 CR 0060, Commonwealth versus Jody Murphy. Are you Jody Murphy?
Yes, sir.
Good morning. You were born in 1999.
Yes, sir.
Last four digits, social security number 6590. We're having a pre-trial diversion revocation. What's the Commonwealth have to say?
Your Honor, this case originated on theft. Ms. Murphy pled guilty to 15 years, pre-trial diversion for 5. She was supposed to pay $250 a month. While she was on probation, she failed some drug tests and also absconded for several months. And so in lieu of revocation of the diversion, she was placed in the Monroe County Specialty Court. And she was terminated from the specialty court because of diluted tests, no show for drug tests, and absconded on 5/1/25.
What do you have to say? Can I stipulate?
Judge, we're stipulating to the violation, but we would like to make an argument in lieu of the pretrial diversion
Please
being
proceed.
voided. Your Honor, I would like to call an alternative sentence worker, Ms. Bethany
That's
Steenbergen.
what?
Alternative sentence worker, Ms. Bethany Steenbergen, to testify.
Okay. You want to take a stand over here?
Okay.
You raise your right hand, swear the testimony that's the Supreme Court president.
I do.
Have a seat, state your name, where you're employed, in what capacity.
My name is Bethany Steenbergen. I work for the Glasgow Public Defender's Office since 2019.
Thank you. And Ms. Steenbergen, can you explain to the court what it is you do, what your job title is?
So to sum it up, I go and do assessments for clients who are typically incarcerated to find them treatment opportunities and develop plans for treatment to help benefit them.
And did you do that with Ms. Murphy?
I did.
Can you explain to the court what it is that the assessment consisted of?
So during Ms. Murphy's assessment, I found out that she is currently pregnant. That pregnant is a high risk pregnancy based off some records that we've already gotten from her doctor. She has lost 2 previous pregnancies due to a specific condition that she has. And while she also has a substance abuse problem, I found her a treatment facility called the Chrysalis House in Lexington that would address all of those issues.
And is this treatment facility, is this something that DOC can monitor?
Yes.
And did you obtain a date which she may be able to go to the treatment facility?
Yes, I have a bed letter for her for June 10th or July 10th, sorry.
Okay. And would DOC be able to provide transportation from the jail to the treatment facility?
Yes, I would get DOC transportation directly from the jail to the facility.
And can you explain a little bit about what
Who pays for that?
It's a grant through the Department of Corrections.
and can you explain what this treatment facility would consist of?
So the reason I chose this specific location is because she would be able to have the baby and return back to treatment. Most treatment facilities, once the person has the baby, they remove the baby and she would not be allowed to continue her treatment. She would be discharged. This program doesn't do that. They allow the mother to remain in their treatment program. Their birthing center is directly across the street, so that they would be able to meet all of her medical needs from the facility, and she would be able to remain in treatment with the baby post.
And how long is this treatment program?
It's a minimum of 6 months, but typically it depends on the person's progress. Because she would be having the baby while there, it would be longer.
Is there anything else that you think that the court would need to know with regard to either Ms. Murphy or the treatment program? I have no further questions. Thank you.
I don't have any questions.
I have a question. If I revoke the pretrial diversion and sentence her, would she still be eligible to go to that location?
Yes.
Thank you very much. You have any other witnesses?
No, Your Honor.
Okay, Mr. Stockton, you have anything to say?
No, Your Honor, I just think that Mr. Murphy's put the Commonwealth in a court in a difficult decision because I know the court wants to have the baby in retail probably, and I would like to do, but she's absconded twice. I really don't have any confidence she's gonna stay in.
Yeah,
I don't say anything.
I have no reason to believe that she will comply. So I'm going to revoke the pretrial diversion, but at sentencing, I'm going to consider allowing her. You know, one of the toughest things I've got to do, two things, to terminate parental rights. It gets me every time, even if it needs to be done. The other thing is to send somebody to penitentiary and them have a baby and immediately that baby be taken from them. And they don't get to see the baby, they don't get to nurture, they don't get to bond. Now, I hope that, I'm sorry you've had these other miscarriages. It's always a tragedy. And I hope those miscarriages weren't related to your drug use at all. I'm not saying they were. I just hope they aren't, okay? But I'm gonna keep you in jail or somewhere. Do you have this baby? Whether it's in treatment or wherever it is, do you have this baby? So I'm gonna go ahead and revoke the pretrial diversion, order pre-sentence investigation for done by probation and parole. When's the next rule day in Monroe?
July 17th.
July 17th, we'll have sentencing over there. And at that day, I'll consider whether or not we let you go to this Department of Corrections location that you have. But you you live at the foot of the cross between now and then. There's stuff in jails. You just need to, for this time period, you just need not to be selfish. You just need to hope that this baby have some semblance of a life that's been better than the one that you've had up to now. You don't want this baby to have the kind of life that you've had or to have any kind of problems. So you just hang in there and we'll see you over there that day. We'll take a look at sentencing. Okay?
Thank you.
Thank you very much. Okay, do we have any more transported prisoners? Is that it? Okay. Tyler Eminette. Hello, versus Tyler Eminette. Mr. Fox, would you like to make a speech or something before you go back to Monroe County?
Y'all have a good day.
Okay. Tyler Eminette.
I believe it not being custody.
Okay. Clifton Carter. Clifton Carter. Commonwealth versus Clifton Carter, 23 CR 0006. Clifton Carter. Clifton Carter, good morning. You born in 1988?
Yes, sir.
Last four digits, social security number 5337.
Yeah.
You're on 23 CR 006 on the pre-trial diversion. What does the Commonwealth have to say? You'll step to your left here, Mr. Carter.
Your Honor, after I filed this motion, I found out that this started out as a flagrant non-support case, 3 years to serve, 3 years probated. Since that time, he's paid all the child support off and he's been released. However, while he's been on supervision, he's been positive for marijuana, got an EPO he didn't report, and has a new misdemeanor arrest. So I don't mind doing whatever the court was, continued since the child support obligation is paid off, but he's not proper.
You have something to say?
Your Honor, this is the first time I've spoken with Clifton, so
Why is that? Why is that?
I didn't have any contact information for him, Your Honor. I wasn't his attorney during the initial charge.
Come back here on August 7th. Come on August the 1st for a negotiation. You got that child support paid, but man, you're gonna have to change your lifestyle. You could still end up going to penitentiary for something you've already paid off. That's pretty rough, isn't it? So you be careful from here. On August the 1st, you come here at 9 a.m. and then on August the 7th, you'll be back here for the court date to see if we can't get you on the right path. Okay.
Judge Tyler, you must release.
Okay, you issue a bench warrant, for Tyler Eminent for failure to appear and hold him without bond. You hear that, Mr. Stockton?
Yes, sir.
Okay, Tyler Eminent has been released from Adair County and he's not here, so I'm issuing a bench warrant, having him held without bond. Derek Garrett. Mr. Martin, which case are you?
He was here on Mr. Carter, so we're finished.
On Mr. Carter, we put Mr. Carter off until August the seventh.
August the seventh, if I can be excused, Judge.
Thank you so much for your appearance. We appreciate it.
Thank you, Judge.
Derek, are you Derek Gary? Yes, sir. Good morning. This is 25CR0015. You're represented by Mr. Poindexter.
Yes, sir.
This is were you born in 1983? Yes, sir. Last 4 digits, social security number 3165. Yes, sir. What do you have here?
We have a plea, Your Honor.
Once you trade places with him and let him know inside there. Is this a felony plea?
Yes, Your Honor.
A motion's been filed, Mr. Gary, says you wish to enter a plea, is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes, sir.
You're the same person that we just identified in 25CR0015.
Yes, sir.
Is your judgment impaired today in any way?
No,
Have you discussed these charges with your attorney?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
With the evidence Commonwealth has against you, and you feel like you're fully informed about the case?
Yes.
You understand you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can step plea, I need to know that you understand those rights. You go through them again, I'm going to ask if you understand. If you don't, you still want to ask your attorney today. You have a right not to testify against yourself. No one can make you say anything. Right to speak, trial of a jury, right to be represented by counsel at your jury trial. You have the right to confront and prosecute all witnesses called to testify against you. Right to produce evidence, right to call witnesses in favor in the process that you compel their attendance. Your right have the right to appeal this matter to higher court to lose, and right to part the Commonwealth prove without reasonable doubt that you're guilty of charge against you. You understand that by entering guilty plea, they give up those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided the law. Prior to accepting your recommendation, I'll have a pre-sentence investigation report done by probation and parole. In the event that I decide not to accept the recommendation and impose a harsher sentence, you have a right to withdraw your plea or trial. You understand that? You step to your left, please. Ms. Gordon Anderson, what do you have here?
Upon a plea of guilty to theft by unlawful taking or disposition more than $1,000 but less than $10,000, 2 counts, the defendant shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years supervised. The defendant shall pay restitution in the amount of $8,200 plus a 5% clerk's fee. Restitution shall be paid in monthly payments at a rate of $150, with first payment being due within 30 days from the entry of this plea. Supervised probation shall continue until all restitution and fees are paid in full. Restitution shall be dispersed to Joseph Hancock in the amount of $7,000 and Carl Winrich in the amount of $1,200 via restitution order submitted with plea. Monthly restitution payments shall be dispersed equally between the 2 victims. The defendant shall have no contact by any means with either victim. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case disposed of in accordance with laws of the Commonwealth and the holding agency.
Is that your understanding, Commonwealth's recommendation, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes.
You do so of your own free will?
Yes.
Okay. Knowing your constitutional rights that I've explained to us, to your desire to receive with your plea without a court conviction, punishment within the range permitted by law. Is that correct? You understand that after entering this guilty plea, you've been convicted felon, and any future convictions could be enhanced under persistent felon offender law. You understand that? Is that your signature?
Yes, sir.
Okay. I'll accept the agreement or pre-sentence investigation report and schedule a hearing on August the 7th. Okay. You're on free on your bond.
Thank you, Your Honor.
Yeah.
That's all I had. Excuse me.
Have a great weekend.
Thank you, Your Honor.
Laura Jones. Commonwealth versus Laura Jones, 25 CR 0057. Good morning. Are you Laura Jones?
Yes.
You born in 1991?
Yes.
Last four digits, social security number 7626?
Yes.
Your percentage.
We do have a PSI, we saw it, but probation only. That would be PSI, but
Yeah, this was a felony plea and I was informed that last week when I went over to that I just did on a pretrial diversion and not the felony, so I'm gonna go over the rights with you.
Okay.
So you understand that you're about to plead guilty to a felony?
Yes.
Okay. And there's certain rights you have before I can say, but I need to know that you understand those rights. If you had plenty of time to discuss this matter with your
Yes.
attorney, you understand the case.
Yeah.
Satisfied in his advice. You have a right not to testify against yourself. No one can make you say anything, right to speed trial, but jury right to be represented by counsel jury trial. Right to confront and prosecute all witnesses, call testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter, higher court if you lose. Right to part of commonwealth period, beyond the reason doubt that you guilty of charges against you. By entering it, you give up those rights. Now, we've had a pre-sentence investigation report done by probation and parole. Have you had time to review that?
Yeah.
And you understand that because of this plea, if you have future felony convictions, they could be enhanced, explored, by the persistent felony federal law. You understand that?
Yeah.
Or plead guilty possession of controlled substance, first degree, first offense, methamphetamine, issues to a year, 2 years, probate for 4 years, however. Will be referred to the social services clinician following recommendation. What's the court cost? 155. You need some time to pay that?
Yeah.
We pay $30 a month, starting 30 days from today, okay? You need to meet with probation parole officer.
Thank you.
Thank you. Michael Keith. I called him. He's back there. You're Michael Keith?
Yes, sir.
We're on 20 CR 0023. Mr. What's your year of birth?
Not
What's the last four digits of social security?
2969.
We're here on three trial contracts. What's the Commonwealth? Commonwealth, come around. Okay, you will get in the middle here, sir. Motion in tender says you wish to enter a guilty plea to that. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 20 CR 0023?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? Or you feel like you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution before I can accept the plea. I need to know that you understand those rights, okay? You're right not to testify against yourself, nor make the same thing right to speak trial, but jury right to represent the counsel to jury trial. Right to confront and cross-examine all witnesses, call testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you are guilty of charges against you. Understand that may a guilty plea, then you waive all those rights. You understand that? Now, I may accept the Commonwealth's recommendation, but I may apply a range of sentence provided by law. Prior to accepting the recommendation, I will order a pre-sentence investigation report and probation parole. In the event that you do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. What's the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to receiving stolen property over $10,000, the defendant shall receive a sentence of 5 years, probated for 5 years. The probation shall be supervised if defendant resides inside the Commonwealth and unsupervised if defendant resides outside the Commonwealth. Defendant shall pay restitution in the full amount of $500 within 30 days from final sentencing. Restitution is subject to a 5% clerk's fee. Restitution shall be dispersed to Billy and Beatty via restitution order submitted with the plea. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in both style cases disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that what you agree to, sir? You're so here on free will, because you did commit the acts. And knowing constitutional rights explained to you, still your desire to give up those rights, enter guilty plea, allow the court to fix your punishment that range beneath the law. You understand? You understand that by entering this guilty plea, you become a convicted felon, and future convictions could be enhanced in a persistent felony under the law. Understand me? Is that your signature on the document?
I don't make it. Or you got it, I'm sorry.
That's your signature?
Yes.
Accept the plea, order pre-sentence investigation report, ask you to come back on August seventh for sentencing.
Thank you, Your Honor.
I need to take a break here just for a second. Let's go off the record. Brittany Gerke, Brittany Gerke. Are you Brittany Gerke?
Yes.
Are you?
Yes.
You gotta say something. We got a voice activated.
Oh,
Microphone. Are you Brittany Gerke?
Yes.
We're making some progress. Good morning.
Good morning.
You're here on 25 CR 0018. Were you born in 1986?
Yes.
Last four digits, social security number 3419. Now you're represented by Jasmine King. Is that right? Is she here?
Carol.
Tom Carroll. Could you have Tom to come out? Tom Carroll.
Mr. Carroll. Your client, because of the
It would be easier to proceed without you, but I didn't think.
That'd probably be all right. I'm
Yeah,
sure Justice.
Miss King is listed, but are you counsel?
I am, Your Honor.
Okay. We're here for a pretrial conference.
We have, and Mr. Stockton's indicated he needs to talk to the victim some more.
We have been active.
If you get over on this side over here, Mr. Carroll.
We have been actively trying to negotiate this case. I believe we've come to a reasonable resolution, but I need to clear this with bluegrass or at least consult about it. So
Okay, you got an August 1st for negotiation day, next court appearance will be August 7th.
August 7th and August 1st.
August 1st is the negotiation day. August 7th is the next court appearance. Both of them are conditioned to your bond, okay?
We'll do that both that August 1st and 7th.
Okay, are we to Megan Kennedy now?
We've got Justice Bailey in custody back.
Okay, we're gonna deal with him.
No.
No, let's wait for him. Let's let him stay back there for a while, okay? Are you Megan Kennedy?
Yes, sir.
This is 25 CR 0046. Miss Kennedy, were you born in 1991?
Yes.
Last four digits, social security 1034.
Yes, sir.
You're in a pretrial conference. What's the Commonwealth have to say?
are you getting a
I'm
conflict?
getting a conflict with this one, yeah.
That Miss Kennedy, Mr. Beatty that we just had the plea on, the loss, I can't think of the other guy's name.
Kevin Miller?
Yeah, Kevin Miller, are all co-defendants.
What are you telling me?
I'm getting conflict counsel for her, Your Honor.
Okay, we'll have conflict counsel with her at a negotiation day on August the 1st here.
Yes, sir.
The next court day is August the 7th, and both of them are conditions of your bond, okay?
Yes, sir. Thank you.
Yeah. Michael Lyens.
Sitting back up, and you stand or do you need to sit? Oh, I can stand for a minute.
Commonwealth versus Michael Lyens, 24 CR 0074 and 24 CR 0008. Are you Michael Lyens?
Yes,
Were
sir.
you born in 1960?
Yes, sir.
Last four digits, social security number 3813.
Yes, sir.
What does the Commonwealth have to say about this case?
We have a felony plea, Your Honor. Okay, it's pretrial diversion, sorry.
A motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Okay, is this plea freely and voluntarily given?
Yes.
Are you the same person we just identified in 24 CR 0074 and 24 CR 008?
Yes.
Is your judgment impaired today in any, is your judgment impaired today in any way? You know
No.
what's going on?
Yeah, I know what's going on.
Okay. That's what impaired means, you know.
Yes, sir.
Did you discuss these charges with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence Commonwealth has against you, but you're fully informed about your case?
Yeah.
Okay. You understand that you do not have to enter guilty plea. Get him those, some of those earphones. Let me get you some earphones so you can hear a little bit better, okay?
Yes.
Yeah, every fuck we agree to.
Is that a little bit better?
Yes, sir.
Okay. You have certain rights under the Kentucky United States Constitution. Now, before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. Understand by entering a guilty plea, you give up those rights. You understand that?
Yes.
Okay. And may consider the Commonwealth's recommendation, and you're going to hear the full recommendation in just a minute. You can listen to what the recommendation is to refresh your memory, okay?
Yes, sir.
Okay, if I do not accept the recommendation after I have if I do not accept the recommendation, then I will inform you and you can withdraw your plea. I'm gonna ask you a few qualifying questions. Have you previously been diverted in the last 5 years?
No,
Have you had any felonies in the last 10 years?
no,
Are you currently on probation?
no.
You understand if you don't successfully complete the diversion program, you could be brought back in front of me. But and I could have a pre-sentence investigation, so you'd be a convicted felon. However, if you successfully complete the diversion program, your charges will be dismissed.
Yes, sir.
Pre-trial diverted and your record can be expunged. You understand that?
Yes, sir.
Okay, is that, come up, Ms. Gordon Anderson, and state what the recommendation is.
This way to start.
What's the recommendation?
Upon a plea of guilty to receiving stolen property firearm, the defendant shall receive a sentence of 3 years, pretrial diverted for 3 years, supervised. The defendant shall forfeit the 22 caliber Hermitage pistol to the Commonwealth and be disposed of in accordance with the law of the Commonwealth and the holding agency. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained.
Now, of course, the employment situation does not apply because you're disabled.
Yes,
Don't worry-
sir.
Don't worry about that. Is that what you agreed to there? What you
Yeah.
just read? Okay. Are you pleading guilty because you did commit the act charged in the indictment?
Your Honor, this is now.
So what you're acknowledging is that there's enough information to convict you, but you don't want to admit the allegation itself. Is that what you're doing?
Yes.
Okay. Are you doing so of your own free will?
Yes.
Knowing constitutional rights is still your desire to give up those rights, enter a plea of guilty and allow the court to fix your punishment. Is that correct?
Yes.
And I'm gonna read it again. Knowing your constitutional rights, as explained, it is still your desire to give up those rights that I explained to you. Enter this plea that I just read and allow the court to fix your punishment. Is that correct?
Yes.
Okay. Is that your signature on the document?
Yes.
Okay, I'll accept the agreement. What are the court costs involved in this case?
155.
Court costs are $155. Do you need some time to pay that?
Yes.
I'll let you pay it $30 a month, the first payment 30 days from today. Now, you don't need to meet with a probation and parole officer just to give them some information there, okay?
Okay.
Okay, thank you very much. Jimmy Massengale.
For me.
Are you Jimmy Massengale? Yes. Good morning. You're on 25 CR 0045. You born in 1972, Mr. Massengale?
Yes, sir.
Last four digits, social security number 3814.
6814.
Do what?
6814.
Okay, we got it wrong on the docket, so y'all make notice it's 6814. Okay, you're here today for a pretrial conference. What is that? Move your lips just a little bit. What does the comment have to say?
Your Honor, we, Mr. Rutherford and I have been trying to settle this case, and I have been dealing with an attorney from, I think, Lexington for the hospital, and I'm gonna have to meet with somebody from the hospital that has some decision-making authority to consult.
What's the case about?
Mr. Massie allegedly committed acts of terroristic threatening while he was at the hospital, making statements like that, I'm gonna kill you or something like that. But he wasn't armed, he didn't assault anybody. And I made an offer that they don't want to accept, or I want to make an offer that the hospital is not in agreement with, so I want to meet with somebody that has some authority.
Okay, well, what do you want to do?
Well, if we can
Negotiation,
pass it, I'm gonna get with the attorney and. tell them-
negotiation day on August the 1.
Yes.
The next court appearance on August the 7th. Okay. Which cases? But we're gonna have to take some things out of order. Clinton County Jail, we have an interpreter available,
Thank you, Judge.
and Antonio Valco Perez, which is 18 CR 006. Madam Interpreter, you raise your right hand, you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
That you will properly, and the question I'm going to ask you is that, are you qualified to serve as an interpreter in the Commonwealth of Kentucky?
Yes, Judge, I am certified by the AOC.
Okay, you can lower your hand.
Thank you.
Antonio Velazquez, is that correct?
Antonio Velázquez.
Velazquez.
Yes.
This is 18 CR 0006 for Reina.
Estamos aquí para su lectura de cargos 18 CR 0006.
Can you afford to hire an attorney, sir, or do you need a public defender?
Señor, ¿usted tiene los medios para contratar su propio abogado o usted requiere los servicios de un abogado de oficio?
No, no tengo los medios para. Si se
Yeah, I have
puede.
a form here that this gentleman has filled out. He has, it appears to me he is qualified, so I'll appoint a public advocate who is to represent him.
Dice el juez que él tiene el formulario que usted llenó para los servicios de un abogado de oficio y él va a otorgar su petición.
Okay, and that's what your name is to this gentleman.
My name is Corey Rutherford.
And he will be your lawyer.
El señor que está al podio, Cody Rutherford, él va a ser su abogado. ¿Ok, señor?
Sí, gracias.
Yes, thank you.
Yeah. I'm going to do an arraignment. The Commonwealth of Kentucky in 18 CR 006 has charged the defendant with incest to 2 counts.
Señor, usted tiene en su contra el cargo de incesto, 2 cargos. En el caso 18 CR 0006, la fiscalía lo ha acusado del cargo de incesto, 2 cargos.
Okay.
Okay.
Detective, will you, counselor, you acknowledge the identity of your client, receipt of the indictment, waive formal reading and arraignment, enter a plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Por hoy lo van a declarar no culpable para constar en actas y el abogado recibió el documento inculpatorio en su caso.
I'm going to set a negotiation day for August the 1st, and the next court date is August the 7th.
La próxima fecha de comparecer va a ser el 7 de agosto.
Sir, your attorney will arrange an interpreter to come over and meet with you, so you and the interpreter and your attorney can meet privately to discuss your case.
Señor Velázquez, su abogado va a contratar un intérprete privado para que ese intérprete pueda ir a la cárcel para conferenciar su caso con usted.
Está bien. Sí.
Okay.
Thank you very much, Madam Interpreter. We have no other need. You may be excused, and thank you for appearing on short notice.
Thank you, Judge. Appreciate it.
Joseph McDermott.
Sí.
Clinton
He
County.
has been pushed out.
Hold on just a second, Your Honor.
Okay, well, we'll wait and get back to him. We're gonna go back to the live docket. We'll move Joseph McDermott down to the Clinton County docket. He was on our live docket. Chesley Post. Chesley Post, are you Chesley Post?
Yes, sir.
Good morning.
Good
You were
morning.
born in 1996.
Yes,
Last
sir.
4 digits, social security number 4594.
Yes, sir.
that we're held a pretrial conference when we have. A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea free and voluntarily given?
Yes, sir.
Are you the same person we just identified in 25 CR 0050?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this charge with your attorney and you're satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes, sir.
You believe that you have been fully informed about your case?
Yes, sir.
You understand that you do not have to enter guilty plea today? You have certain rights in the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes, sir.
I'm gonna go down through the rights and at the end, I'm gonna ask you to understand them. If anytime you need to ask your attorney questions, step away from the microphone, okay? You have a right not to testify against yourself. No one can make you say anything, right to speak, right to jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and right to apply the Commonwealth with under reason without your guilty charges against you. Understand that you're in guilty plea. You give up all those rights. You understand that?
Yes, sir.
Yeah, I may consider Commonwealth's recommendation, but I may apply any range of sentence provided. Well, if I reject the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty. You understand that?
Yes, sir.
Okay, have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the past 10 years?
No, sir.
You understand that if you fully complete the diversion agreement, it will be dismissed pre-trial diversion. You can have it expunged from your record. You understand that?
Yes, sir.
You also understand if you do not complete the diversion program, you brought back before me and I revoke it. And I'll schedule a pre-sentence investigation report to be a convicted felon that can be used against you in the future to enhance penalties. You understand that?
Yes, sir.
What is the Commonwealth's recommendation?
Yes, Your Honor, upon a plea of guilty to operating a motor vehicle with alcohol concentration over above 0.08 or while under the influence of alcohol or other substances, first offense aggravating circumstances, the defendant shall serve 4 days in jail and pay a $200 fine and cost. Defendant has served the 4 days and shall receive credit for time served. Upon a plea of guilty to possession of a controlled substance first degree, first offense, methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years, supervised. The defendant shall enter and complete the Clinton special report. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in accordance with in manner with the laws of the Commonwealth and the holding agency.
You realize that the DUI is, come over here. You realize that the DUI is enhanceable too if you ever get another DUI, right? You understand that?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
Okay, you're doing so of your own free will?
Yes,
You know
sir.
your constitutional rights explained to you, it's still your desire to give up those rights. And you're guilty plea and allow the court to fix your punishment.
Yes, sir.
Set your signature on the agreement.
Yes, sir.
I will sign the diversion order. You need to meet with probation and parole. What are the court costs of this case?
You on there, $820.
$820. You need some time to pay that?
Yes, sir. I'm currently without a job,
You what?
but I'm currently without a job.
Okay, well, I'll let you pay it, $40 a month, first payment being 30 days from today, okay?
Okay. Thank you.
Okay,
Oh, and Your Honor, she has her license here as well.
good. Seth Roberts, probation parole officer, Seth Roberts. Seth Roberts been served.
No, I was also going to say.
Yeah, I said, I love him. He was so.
Oh, we had him, sir.
Could you check, see if the right court date's on there?
When I look this up to try to find him, he's not showing it in custody, but it's also not showing that he made his bond, so I'm not. I don't know. But he was served on June 23rd.
When the parole bond, they ran 3 years.
Well, bond was set on the indictment.
I mean, he had posted. Carson, did you see if you can locate him? She's looking at.
Let's go while we do, it's Seth Roberts, right? Let's go on to, Robert Smith.
Yeah, that's the Commonwealth's notice of motion to forfeit its rifle and ammunition.
Is there any objection? If not, we'll enter. Nathan Scott. However, Nathan Scott. Smith and Stockton, excuse me. Commonwealth versus Nathan Stockton. 25 CR 0036 and 25 CR 0020. Are you Nathan Stockton?
I am, yes.
Good morning. You born in 1991?
Yes, sir.
Last four digits, social security number 5920.
Yes, sir.
It was the Commonwealth have to say about Mr. Stockton's case.
Mr. Rutherford and I had some discussion on this case. He was appointed last month, I think.
Yeah.
If he wants one more trial date, one more pretrial, I'll grant it since he's been on the case. But if we don't get some resolution next month.
Negotiation day on August the 1st, next court date on August the 7th. You're under the same conditions your bond. Make sure you talk to your lawyer and are ready for the August 1st negotiation day, okay?
Thank you.
Joshua Talent. Commonwealth of Kentucky versus Joshua Talent, 25 CR 0028. You born in 1989?
Yes, sir.
Last four digits, social security number 3393.
Yes, sir.
Hey, it says suppression here. Go ahead. What kind of search we have, Mr. Stockton?
It's, Mr. Talent had a red and alternating blue light around his license plate at 1:30 a.m. in the morning. Deputy Pendergrass pulled him over. I think there was some marijuana. Sorry, he had a problem with alcohol based on the traffic violation. Found marijuana, he Mirandized Mr. Talent. Townsend told him they had methamphetamine, which he found. He's charged on possession. It's basically the facts of the case.
I would have to contest that, Your Honor. That's why we're having
Well,
this.
that's what's in the citation, but he was, Deputy Pendergrass is in the grand jury right now, Cindy can go.
You're all.
Okay, we'll call this case back up.
Thank you. Thanks.
Now, do we have anybody else live here ready?
I'm there. Come back up here.
We can make it back again.
I'm set for all this, we have one of those, okay. It's not important that, but the file indicates that you gave him a $5,000 surety bond once he was picked up. The collection from the investigation. It's not showing that that bond is made.
Are you Justin Daly?
Yes,
Good morning. This is 24 CR 0079, Commonwealth of Kentucky versus Justin Daly. Mr. Daly, were you born in 1989?
Yes, sir.
Last four digits, social security number 6037.
Yes, sir.
You're on a pretrial conference. What does the Commonwealth have to say about this?
Your Honor, we'll
You
need
want
it.
to come on up before we get you on camera? Mr. Daly, you step over to the left here just a little bit there. Thank you, sir.
We'll need a trial date. I'm just trying to decide, ask for what was the we got a murder trial.
What is the charge here?
This is sexual abuse, rape. And the victim child was in several, over 100 miles away from the home. So I'll have to have legitimately without meeting her. Met her one time. And then we've got Robles in August. And O'Donnell in October. So I would say, also I've got Riddle in Herman County, which Judge Lance in September. So I don't know what timeline Mr. Rutherford's looking at as far as trial date. I know Mr. Daly's a state prisoner. But I don't know how long you've got to serve.
When's You what?
Can I speak to y'all?
Well, step over there and talk to your attorney first, and then we'll see what's gonna say, gonna hurt
I just
you.
need to make sure I always got to tell me, I need those things, it's on her phone, 4 or 5 hours away. I need to be updated on all this, look, I don't know if we're going to with my life, or something I ain't know. Yeah, I see, this is,
Okay, I understand what it's about. Come back up here.
Thank
Now, one of the things that I insist is when someone is incarcerated, I could overhear some of that. You have an obligation to keep this man informed and go visit him personally, face to face. Now, if you can't handle that, then we need to get him appointed to somebody.
I can't handle it.
You can get him appointed or.
No, I can handle that.
Okay, well, before he leaves here today, I want a time certain that you're gonna go meet with him and talk to him about this. Because I don't know whether this gentleman's done anything, or he hadn't done anything, but one of the most cruel things I can think of is let somebody sit in jail there without keeping them informed and having no way to get out. And that causes problems for the prisons. It causes problems for everybody involved to not keep everybody fully informed.
Right.
Now, you want to set a negotiation
We
date?
had negotiation days, all right. This is a situation, probation parole. Mr. Daly is not eligible for parole. We've got a serve out date of September of 26. We might get MRS, which might make it March or something. I want to give you a trial date before he gets out.
Right.
So I would think November, December, January. something
Okay,
like
well,
that.
let's go down. Let's go down to November then.
We're loaded up between now and.
Okay, let's go down to November.
Jason, he does have a holder, so if he was to make MRS, they would just ship him back here. Yeah. Yeah.
Is there an election? There's not an election. Yeah, I mean, I got election day, I mean, we can't do an election, so that's just.
Your Honor, I don't think I would say it, you're talking about election day, November. I don't think I would say it any time early in November, because I don't know how long this, Donald's going to last. I've got 65 weeks.
Okay, let's,
If I can get him out of here.
let's go to, let's go to November the 11th.
It's still too.
Okay, all right.
Yeah, that's dangerous.
I don't have that on my calendar.
And it's gonna be hard to work on this case, when I'm in trial. and then-
Well, I understand. You convince me. How long will this case take? 1, 2 days?
I would think sometime maybe the second week of December, or not January, second.
No, I'm not gonna be available second week. What about December the 1st? December the 1st.
That works for me as well.
Okay, now, I don't know, what evidence, you have forensic evidence in this testimony, so you need to take a close look. This is a serious charge. And you need to take a look, to see if you need to make any ex parte motions to get any expert witnesses or anything like this. Yeah, I don't want to wait right up on it. You understand what I'm saying?
Yes, sir.
Okay, and then when are you gonna be able to, when you gonna be able to go up, see him?
I will see him and update him on everything either Friday or Saturday.
Okay, this week. Okay. And we don't have another pretrial schedule for this. I'm just gonna put a jury trial there. We have a jury trial on there, so I'm saying if there's a necessity to have any suppression hearings or anything else, we can reset it. Thank you very much for coming down today.
Thank you. Your Honor, Deputy Pendergrass is here if you want to go ahead and take the talent suppression here.
Do we have any other, do we have Russell County on there? I had them scheduled. Russell County, are you on there? Nobody's on, so we can do the suppression hearing. Where is it? Where is that case at? Cromwell versus Joshua. Where's Mr. Cross? Okay, you want to call your first witness?
Deputy Pendergrass.
Here you take the stand, you raise your right hand, you swear the testimony not gives the truth, no truth, nothing but the truth. Take a seat there, lean into the microphone and tell us, with whom you're employed and what capacity.
Thomas Pendergrass. I'm employed with the Clinton County Sheriff's Office.
And Deputy Pendergrass, how long have you been employed there?
Approximately 2 years,
How long have you been a police officer?
3 years.
Okay, have you been to the academy yet?
Yes, sir.
Okay. I want to ask you about the events that occurred on February the 20th, 2025. Did you have an occasion to see Mr. Talent?
Yes, sir.
Could you tell the court what happened?
Yes. So on that above date and time, I observed the above.
What was the time?
The time was February 20th, 25, approximately 1:30 a.m.
Okay, go ahead.
I observed a white Ford truck traveling northbound on Business 127 with a blue light illuminating the left side of the license plate and a red light on the right side of the license plate.
Okay. Is it permissible to have blue lights on your vehicle if you're not a first responder or a law enforcement?
Sir, it's against KRS to have a blue light on your vehicle.
Okay, go ahead. So what did you do?
So upon traffic stop, I observed Joshua Talent operating the vehicle. I asked for his license, to which he could not provide. I asked Talent if he had anything illegal inside the vehicle. Talent stated he had some marijuana in the vehicle, and then he handed me a square-shaped plastic container with a green leafy substance inside that he had in the center console. Talent was then asked to step out of the vehicle and was detained and read his Miranda rights.
Okay. So at this point in time, after you discovered the marijuana he handed to, he was Mirandized.
Yes, sir.
Okay. What happened next?
Upon questioning, Talent stated that I would find dope in the console area underneath the radio. In the console area underneath the radio, I found a clear bag containing a white powder substance, which was suspected methamphetamine, as well as a glass pipe containing white residue. Talent stated to me that the substance was methamphetamine. Talent also had a mason jar with green leafy substance in the console, which was suspected marijuana as well. Talent admitted to using methamphetamine earlier in the night, approximately at 7 p.m. Talent was given the HGN portion of standard field sobriety, but he was not under the influence at the time.
So he was not charged with DUI?
No, sir.
What was he charged with?
He was charged with the improper use of a blue light, no registration plates, drug paraphernalia, and possession of controlled substance first offense.
Did you check and see if he had a valid license even though he didn't have one with him?
I checked for his license status at the time. I believe it was valid.
Okay, so he wasn't charged with not having a license?
No, sir.
Okay, I don't have any further, and now, you said the business end of 127. Tell us about where this was.
It was about kind of at the courthouse there. The traffic stop happened on Clear Street.
Okay, okay. So was it Clinton County?
Yes, sir.
Okay. I'll pass it.
Thank you, Mr. Stocker.
Deputy Pendergrass, do you have anything other than the citation that you're refreshing yourself with?
Yes, sir, my neighbors.
Right.
Yes, sir.
Examine it your own.
Yes, sir. This is the whole thing in its entirety in this fact sheet. It's the same area that this was citation, just copy and paste. Thank you.
Now, Deputy Pendergrass, we know what the KRS says about blue lights and red lights, and it says you're not supposed to have a blue light.
Yes, sir.
Correct. But we also know that Mr. Talent has been seen by you numerous occasions before, and you've never stopped him. Is that correct?
Yes, sir.
Okay. And would it be fair to say that until the night of the 20th of February at 1:30 in the morning, you just felt like that he was not in violation of the law by running that little small blue light?
No, sir. The times that I'd seen him before, I was on my way to a call or on my way to dispatching paperwork. This night in particular, I didn't have anything else going.
Okay. So you, in regard to strict compliance with the law, it does appear that he was not in compliance. But this is something he'd apparently driven around for months and nobody had ever said anything to him, correct?
That would be correct.
Okay. Now, you stop him and he gets out of his vehicle, or did he remain in the vehicle?
He remained in the vehicle.
Okay. Okay. Could not produce his license. At what point in time did he get out of the vehicle?
When I asked him to get out after he handed me that first bag of marijuana.
Okay, okay. So when you first approached the vehicle, what did you tell him regarding the blue lights?
Just advised him what the traffic stop was for initially. Just advised him that he had a blue light and a red light on his license plate, and that was the reason for the stop.
Okay. Did you in fact tell him at that point in time that you were not going to write him a citation? You just wanted to advise him what the law was?
I didn't put in my citation. I'm not sure. I can't remember.
So it's fair to say you do not recall the specifics of that, correct?
Yes,
okay. And based on your testimony, you inquired of what he had within the vehicle before you Mirandized him. Is that correct?
Yes.
Okay. That's all I have.
Just a couple of follow-ups on redirect. Did you know who you were stopping that night, Deputy Pendergrass? Were you familiar with that vehicle?
I was familiar with the vehicle. I did not know Joshua Talent personally.
So you didn't know who the occupant was or the driver?
No, not directly.
And just to be clear with Mr. Cross, you had seen that vehicle before?
Yes, sir. I had seen the vehicle.
And you had observed the blue light before? Or
I had not observed the blue light directly before, but I'd seen the vehicle.
Okay, that's what I wanted to clarify.
Yes, sir.
So you've acknowledged you've seen this vehicle on numerous occasions, but now you're saying that you hadn't known blue light before. Is that what you're telling us today
Yes, sir.
now?
That is correct.
No further question.
I don't have
Any other witness? Be excused.
Thanks. We call it.
You have any other witnesses?
No, no.
Take a stand. Raise your right hand, swear to testimony that you get the truth, whole truth, nothing but the truth.
Yes, sir.
Now, you have a right not to testify against yourself unless you don't have to say anything. You can discuss that with your attorney. You waiving that right?
Yes, sir.
Okay, go ahead.
Thank you. State your name for the record.
Joshua Talent.
Josh, you were stopped on the 20th, the morning of February 20th by Deputy Pendergrass. What vehicle were you driving then?
I was driving my black Ford F-250.
How long have you owned that?
3 years.
And have you lived in Clinton County all that time?
Yes, sir.
Now, when you bought that vehicle, was there something unusual about the rear license plate?
I never noticed it. I never paid any attention to it. You know, that's how it came whenever I bought it, you know.
But just for the court, there's one red light and one
There's
blue
one
light.
red light and one blue light.
Very small, right, okay. Okay, now,
It's the one that illuminates your license plate so you can see the numbers.
okay, and there's one on one side and one on the other.
Yes.
Okay. Have you been stopped by any other police officer in that regarding that at any time?
No.
Now, you heard Deputy Pendergrass's testimony. I want to ask you particularly, what discussion did he have with you regarding the improper use of blue lights?
He told me that you couldn't have a blue light illuminate your license plate, and that I asked him, I said, well, do you want me to get out and take it out? That way, you know, it's not, that way I can fix it. And he said, no, I'm not gonna make you get out because it was snowing. It was like, there's literally a 4 inch snow on the ground. And he said, no, I'm not gonna make you get out and do it. I'm not
Okay,
gonna write you a ticket.
okay, so he specifically stated at that point in time, he was not going to give you a citation.
Yes.
Okay, and then what did he do?
He started to walk back to his vehicle, and then, because he was out of my peripheral vision, and then it's like you'd see, he just kind of stuck his head back sideways. And do you have anything illegal in the vehicle, by the way?
And you told him you did?
Yeah.
Okay, and basically what he said from there on, you basically agree with, you
Yes,
told
sir.
him you had some marijuana and there was some dope.
I agree with everything except the Miranda rights. I was never Miranda right.
Okay, never.
Never.
Okay. All right. But it's your testimony today that the purpose of the stop was over based on him leaving your
Yes.
your vehicle. That's all we have.
Town, I looked it up, February the 20th, that was a Thursday. You remember what day of the week it was?
Thursday.
Yeah, what was you doing out that late at night on a Thursday?
I was literally in the parking lot of the Kings of Kings Pizza, trying to find some change to buy a piece of pizza at the Cumberland Corner Mart, because my woman and I were having trouble and I'd left, and I was just trying to find some change to buy a piece of pizza at the corner mart. And a snowplow truck, because it was snowing, was coming around through there, and I apparently was in the way, sitting there, and I had to get out of the way. So I pulled out, and the police vehicle got behind me.
Whose residence were you coming from?
I wasn't at a residence. I was sitting there in the parking lot.
I know, but you said you and your lady friend had trouble. What was her name?
Her name's Kelly
And what's her last name?
Thomas.
Thomas. Had you come from her residence?
Earlier in the day, yes.
Okay. And then you were earlier in the day, so if you had done something to occupy your time from the time you left to 1:30 in the morning, is that correct?
Yeah, I mean, yeah.
You just come from purchasing the methamphetamine?
No, sir.
Okay, where did you get that from?
I bought it from, someone else.
Well, you don't want to tell us? You
Uh,
took the stand, you're accusing Mr. Pendergrass of not telling the truth, and now you don't want to tell us the truth. I'm kind of the boss.
I didn't say I didn't want to, tell the truth.
Well, tell us who you bought it from.
A defendant in custody.
Okay, well, that person have a name? That's a question.
Yes,
Well, what is the name?
Brandon Hall.
Okay. And did you purchase it that day?
No.
Did you had it for a while?
Yes.
Okay. And your testimony is that you've got this meth, you're driving around with it. Mr. Pendergrass just made this up so he could get you arrested.
I don't see what part he made up.
Well, the fact that he Mirandized you,
Uh,
that he read you your rights. You're saying he
oh,
didn't
no,
do that.
I was never read my rights.
Nothing further.
Redirect.
No, Your Honor.
You may stand down, sir. You have any other witnesses?
No, we have no further.
You gonna make your argument, you start?
Yes, Your Honor. Give me just a minute. There's no doubt, Your Honor, under the statute, that this was a valid stop. KRS 189-950 prohibits anyone from having a blue light in the vehicle other than law enforcement or first responders. The Supreme Court took this case up in United States versus Wren about pretextual stops and whether or not you can look at an officer's motivations. And basically, the Supreme Court says that once there's a probable cause for a stop, which there was in this case, that an officer who has probable cause to believe a traffic stop has occurred may stop a vehicle regardless of his or her subjective motivations. And in Derek Green versus Commonwealth, 514 Southwest 3rd, 566, basically the Kentucky courts adopted that rule. So I don't see what the argument is here. We had a valid stop. He consented to the search. He produced the methamphetamine.
Your Honor, my worthy adversary is correct in regard to the technical aspect of the stop. The stop itself is valid, even though it is pretextual, clearly, because this young man's been driving this vehicle around for 3 years and nobody stops him until 1:30 in the morning. Well, what that tells us is what Deputy Pendergrass really had on his mind, and that's fine. But, Your Honor, number one, the statement that led to the search was apparently now made before he was Mirandized. But what's clear, absolutely clear to this, is the purpose of the stop was over until he comes back and says, "You got anything in your vehicle?" You know, and then he
Illegal. Anything illegal?
Yeah, anything illegal in your vehicle. And of course, that led to Mr. Talent, who is probably one of the hardest working men in Clinton County based on what he does and what they do. And it's clear, Your Honor, that the purpose of the stop was to check Mr. Talent out, see if he's all right, notify him about his violation, and then the officer, according to Mr. Talent, said, "I'm not going to write you up." He subsequently did write him up because he found something, because of Mr. Talent's candor. So we feel like that clearly under current Kentucky law, the stop was extended, and I've asked that therefore the search be
What's the proof of the extension?
I'm sorry, Your Honor.
What's the proof of the extension this time? He said he was walking away, he put his head around and said, "Is there anything illegal in there?" How much did that extend the stop?
Your Honor, our position is
How much did it extend?
it wouldn't matter. If it's just a few
It
seconds.
matters to me. I want to know. That.
Okay.
I ask you.
Your Honor, the case law says if the purpose of the stop is over, then any extension is impermissible. Your Honor, I'll be happy to brief this for the court. Pretty big issue for Mr. Talent, and I'd like an opportunity to submit a brief for, give me 15 days.
What's Commonwealth saying?
Well, Mr. Cross has not cited any cases today, and I'm not aware of any draconian cases he cites. If he's got a case, I would like to look at it and respond to it, because I'm not aware.
Well, no, I thought I would just file a brief on it, Your Honor. And that's what we'd like to do. So 15
I thought
days.
it was a pretextual stop, just the basis.
Well, and that's what I heard. I don't, if you look at the motion, though, it's the stop was also extended. Sorry, didn't know.
Well, I didn't.
Well, go ahead and brief it. The pretextual stop issue is not an issue in the state. So the extension and any reason that the evidence I present, just file a brief within 15 days. You can have 15 to respond.
Thank you, Your Honor.
Let's set this to come back on August the 7th.
Okay.
We'll set a trial date. Where are we at? Y'all want to clear that area over there?
Mr. Shaw, nobody knows where he is. No jails have any records who be brought on the day that the warrant was served. There's no paperwork saying that he made bond. We put a call into the officer that served the warrant, and he's off work today, so the sheriff's office in Wayne County is trying to reach out to him. We can remember.
What's he charge? What's Mr. Shaw charge? There wasn't any return on the warrant.
The warrant was served.
See what the,
I can tell you about, they got a call, the warrant was served on June 3rd by the deputy sheriff.
see what's the risk.
Yes, the warrant was served, it was arrested, there's nobody has a record. The warrant was served, anybody want? You don't know. The warrant was served, pre-trial, called judge, he changed the bond. But that's as far as the paperwork goes. Now he's not in custody, nobody has any records.
Her child called me and told me that he previously made that $5,000 bond. And that bond would be okay.
This was a flagrant on-support case, and his bond was the full child support amount. The pre-trial call, he changed it to $5,000 surety. Because the record is silent.
I don't know why we ever done that. I didn't, I'm not saying I didn't do it, but it doesn't sound like anything I got to do there.
this stuff here, okay? Good.
She spoke with his daughter, and they alive. He was in custody, I was jailed. Thank you.
Okay, who's next? Who's next? Grand jury, bring your grand jury in. Bring your grand jury in.
All right, the grand jury.
Oh, no, she's not the real person. Leina, she's not the real person.
Okay, everybody can be seated now. Who's the foreperson of the grand jury? Madam foreperson, did 9 or more of you agree on the document that you have there?
Yes.
Will you hand it to the bailiff and you can have a seat there? Thank you, sir.
Mr. Shaw, name on and it's giving July. Seth Roberts.
Seth Roberts was given the wrong court date, jail.
What date was given?
July 10th.
July 10th.
Yeah.
I was.
So if he comes up here on July 10th, they just need to give him a new court date of August the 7th. Send him a summons. Okay, there's no reason to arrest him. Okay, ladies and gentlemen, everything seems to be in order. I will sign the documents and have warrants issued to serve on the individuals that y'all have seen fit to indict. The amount of bond will be set sufficient to assure their attendance and to protect the public if anything they've done is a danger to the public. Will, once they're picked up, they'll be interviewed by pretrial and we'll see if there's if the bond's excessive, but they can't make it. So the next date that you're to be back here is on August the 7th, unless called back in for a special grand jury in the case of riot or insurrection. I'm not expecting riots or insurrection, but these days one can't tell the way things are going on in the world. So thank you for your service today. I want to remind you that everything that you heard or said in the grand jury room is to be kept confidential, okay? Thank you. You may be released. All rise for the grand jury. Clinton County Jail, if you'll turn your camera on. Clinton County.
Did you say Joe?
Clinton County. Well, turn your camera on. Mitchell Finley.
Yes, hello?
Mitchell Finley.
Mitchell Finley, hold on 1 second, sir.
We're not quite ready.
Yeah, we are.
Well, Cross just came up and said he'd be up later on, which would be, it was scheduled at 12:30.
Well, that's when the conference hearing is scheduled, but my understanding was he was gonna stipulate.
He said, I think we've got it settled, but he said, so we may not have to hear him, but I'll.
Just continue to next month. He can't be here when it's supposed to.
Okay, August the 7th. Mr. Finley, your case has been continued to August the 7th, okay? Thank you very much.
I say I've got the doctor tied up for no reason.
I understand. I've just continued to August the 7th.
I'll calm down.
Okay.
Your Honor.
Yeah, your attorney will be over to talk to you, okay?
Okay.
Thank you very much. Joshua Minton. Commonwealth versus Joshua Minton for sentencing. Joshua Minton. Hello?
They're going to get him, Your Honor.
Have you got a list there? Who else we're gonna call? Dylan Murphy is next, okay? Commonwealth versus Joshua Minton for sentencing. You are Joshua Minton.
Yes, sir.
You're on 22 CR 008. Were you born in 1987?
Yes, sir.
Last 4 digits, social security number 8105.
Yes, sir.
Okay. Okay, you were on November 3rd, 2022, you were given a pretrial diversion. On June 8th. The previously granted pretrial diversion was voided. You Commonwealth had recommended 3 years. Do you have anything to say about that, counsel?
We stipulated to that.
They stipulate, I know that, but you have anything to say for a sentence?
No.
Okay, the defendant shall receive 3 years, but shall receive credit for all time served. Okay. Thank you very much. Dylan Murphy. Dylan Murphy. Caleb Purdue is after him. Commonwealth versus Dylan Murphy. Are you Dylan Murphy?
Yeah.
Okay, good morning, Mr. Murphy. This is 23 CR 0057. Were you born in 1996? Mr. Murphy, were you born in 1996?
Yeah,
The last four digits of your social security are 1303.
yeah.
You're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report and the probation pro? Is it substantially correct?
Yeah.
So, Counselor, is any reason this gentleman should not be sentenced?
No, Your Honor.
On March seventh, the Commonwealth recommended a sentence of 5 years on each count pretrial. The verdict on June the 18th, previously granted pretrial diversion was voided. Now, were the two counts to run concurrently? Is that right, Mr. Stockton?
I'm sorry, Your Honor, what?
Were these two counts to run concurrently?
Bill Murphy. No, that's. Joshua Minute. Joshua Minute.
Well, I'm gonna run concurrently.
That's my understanding.
Here, 5 years.
They are.
Two of them at the same time, but you're gonna run both of them at the same time, so you're not gonna get 10 years, you're gonna get 5 years, okay? Okay,
No.
thank you very much. Caleb Purdue. Caleb Purdue.
Yeah.
Are you Caleb Purdue?
Yes, sir.
Good morning. Were you born in 1994?
Yes, sir.
Four digits, social security number 2966.
Yes, sir.
You're here in 21 CR 0022 for probation revocation. What does the Commonwealth have to say?
Your Honor, we were here last month on this case. He has a 10-year sentence on his plea, but he was placed on inactive August the 1st of 23 after graduating from drug court. He got a new misdemeanor arrest in April of 24. He was sent to treatment, completed that. And he's had 2 recent tests for positive for methamphetamines. You ask probation parole to check and see what would happen if he's revoked. He's got 439 days jail credit. If he's revoked, he would meet the parole board in April of 26.
Yeah, and Your Honor, we just asked that the Commonwealth, the court consider doing something like home incarceration with the work release, and he would attend IOP. He just, on Monday, his 2 children and grandfather were involved in an accident. They had to fly him out to UK hospital. And I think he wants to be there for them and try to help them as they recover from that.
Well, he's been a drug court, he's been in treatment, he's testing positive. I don't know what else to do. And he's got a wife, or I don't know their situation, Taylor Phillips, that sent her to long-term treatment. She was about the same situation. We sent her to treatment while she was pregnant. Instead, Mr. Purdue don't have that affliction or blessing. Blessing, she'd say.
And Your Honor, he's done well as he's been incarcerated there. He's a trustee right now.
Well, I mean, yeah, people do well, but he won't, he's violated, but I don't understand. Is there
I guess.
where's he working at? Does he have a job?
Yeah, it's a Purdue drywall.
Yeah. Mr. Purdue, do you value your freedom at all? Does it matter?
Yes.
Back away from the camera just a little bit so we can see. I mean, what is the deal here? I mean, you got a child on the way, you got people hurt, father hurt in an accident, and this. What is it that we're gonna have to do to get you to comply? I don't understand. I mean, do you want to go, are you wanting to go to the penitentiary, or I mean, is there something?
No, sir. No, sir, I do not. I've been doing really well, Your Honor, and I messed up one time, and I apologize for that, and that's my fault. And you know, if you are willing to give me one more chance, I will show you all that I can do it. It's been a long. I've made so much progress in the last 4 to 5 years, Your Honor, and I want one more chance to show you all that I can do it. I mean, it's been over a year since I had used any drugs. And, you know, I'm making progress.
Is that dirty test the only violation?
I think so, and I agree with Mr. Purdue. From the time, I think I sent him to prison several years ago when he ran off, and then he got in drug court, he has made a lot of progress. He just won't give
How
up.
many days has he been in now?
Been in where?
In jail.
In jail.
How many days has he been in jail? How many days you been in jail?
Since May 29th.
Well, where are you gonna, there's nobody doing any drywall around, so I won't ask you if there's not drywall work. Is that what you're gonna do, drywall?
Your Honor, me and my uncle run the company and sometimes it's slow, yes, but, if I was to get back out, I'm gonna start working with Tyler Huddleston, welding vats at my cousin's house where my kids are located right now.
Well, I'm gonna take the revocation under advisement and we're gonna review it again on September the 11th.
That's fine. I would ask for an order of probation parole to be under heightened supervision with drug tests, make sure he's doing what he needs to do.
We're gonna make you under heightened supervision and you're waiving your Fourth Amendment rights as far as search. And I'm gonna release you. Probably, I'm gonna wait till like Monday, release on Monday. Yeah. And then-
Caleb, as soon as you're released, report straight to the probation and parole office.
Yes, sir. Yes, sir.
Caleb, I'm telling you, this is it. You
Okay.
understand what I'm saying?
Yes,
Okay.
sir. I understand.
Okay, David Sullivan.
Give me just seconds, Your Honor. Here he is, Your Honor.
Commonwealth versus David Sullivan. Are you David Sullivan?
Sir.
I've looked at your statement here on finances. It's you born in 1980?
Yes, sir.
Last four digits, social security number 6949.
Yes, sir.
You're here for the purpose of arraignment. I'm on a appoint public advocacy. But I'm just curious here. They asked you on your employment record that you could not remember when you were previously employed. Are you disabled?
No, sir.
Well, what's the deal? I don't know anybody that can't remember when they ever had a job.
It's been about 2 years, Your Honor.
What's the deal? Why aren't you working?
I just haven't been working, Your Honor. I don't know.
How do you live? Who do you live with?
I was living with my mother, sir. My house caught on fire in Tennessee down there and burned up, and then the police picked me up for up here when they come to put the house out. Said I had a warrant out of Clinton County, so they picked me up. But they'd been to the house once before to pick me up.
Okay, I don't want to go into detail. You haven't given me a plausible excuse, so I want to tell you, I take into consideration how people ultimately are sentenced and things on whether they make any effort to be a contributive member of society and support themselves. And anybody that was born in 1980 and still living with their mother and not working makes me a little suspect of what's going on. You're here for the purpose of arraignment. You have a right to remain silent. Your attorney's here. Grand jury of Clinton County returned a indictment charging with speeding, disregarding traffic regulations, failing to wear a seatbelt, expired plates, wanton endangerment in the first degree, 2 counts of wanton endangerment in the second degree, fleeing or evading, reckless driving, operating motor vehicle under the influence, and criminal mischief. You understand what those charges are?
I do, Your Honor.
You acknowledge the identity client receiving that in the way formal legal and interplead not guilty, reserving all pretrial motions.
Yes, sir.
What's the bond say?
You would second that no longer.
Yeah, I'm gonna say that $50,000 cash. Okay, you be for negotiation on August 1st and on August 7th, your next court day, your attorney will be able to see you, Mr. Sullivan. Okay? Thank you. Now, do we have anybody else there? Do we have anybody else there at the jail? Let's wait and see. I guess we have McDermott. Is McDermott there? Joseph McDermott. Okay, you turn the camera back on for Mr. Joseph McDermott. Okay, Commonwealth versus Joseph McDermott. 24 CR 0023. You Joseph McDermott,
Yes, I am.
1985.
Yes, sir.
Last four digits of your social security number 5733.
Yes, sir.
What do we have, Mr. Stockton?
He was the one where the bond, there's the
Yeah, come on up here,
miscommunication
we'll
on.
get you, yeah.
He was the one where there was miscommunication on the bond, had the wrong court date on it, and made the bond. And so I would just ask for a negotiation and a.
And what is this bond now?
You would second.
Why was that?
He meant NCIC probably.
Yes, we were in contact with Mr. Sullivan to find out more about that case.
Well, it was a 24 case.
That's correct, and I couldn't get, I don't know if they couldn't find him in Wayne County or what, but he was a Wayne County resident when I died. So I don't know why he was an NCIC so long.
What was the bond initially said?
It's a for $25,000 surety bond.
It's 25,000 surely, okay.
Yeah, I think that would be fine.
Okay, well, had he previously made $25,000 surety?
He made it incorrect bond of $20,000 surety.
The only problem I had with the $25,000 surety bond is you couldn't tell who the surety was. You
Who is
read
the
the bond wrong. It was illegible.
It's $20,000 surety.
House.
It's a Karen. Maybe. He may go over this.
Who was on your surety, Mr. McDermott?
Robin Nevels.
Was that surety approved at your clerk's office, clerk, you know?
Yeah, it is, he had her back and then also he had. Different reason.
Okay, are you a Kentucky resident?
Yes.
In Wayne County. Why was the bond taken out of 25,000?
Maybe an answer.
Because he was in NCIC.
Yes, Birmingham and so on.
See, I thought that he probably out of state. Brought back in NCIC, was arrested in state.
Yeah.
I'll reinstitute your bond, your surety bond, so you can get out today, okay? And your court, you'll need to be here on August the 1st with your attorney for negotiation and August the 7th, and both of them are condition of your bond, okay?
Okay.
Judge, I believe the surety's been released and that one, so we'll have to repost it.
So somebody will have to come in and post the bond. But the
Okay.
previous surety has been, so as soon as they come in and post $25,000 surety bonds, what I'm gonna make it, somebody come in and post it, get approved, you can get out, okay? On bond.
Thank you.
clerk only approved a $20,000 surety bond previously, so it will have to be reapproved by the clerk for other than 25.
You got it? Okay. Okay, thank you very much. Is there anybody there at the Clinton County Jail that we hadn't dealt with? You don't have anybody else there?
Should be it.
That should be it, Your Honor.
Thank you very much. Yeah, we never did get the Russell. Long way.
Murphy. We done his, we done doing.
Oh, Ms. Travis.
Russell's still not on, Megan?
Plea for next trial. With a Michael. Okay. Yeah, we'll be good for 45.
Let's go off the record for a second here until Russell
You're not
County,
on.
Russell County, turn your microphone on if you would. Thank you. Thank you so much. Harbor, Commonwealth versus Haley Harbor. This is
Yeah.
4 CR 0089, Commonwealth versus Haley Harbor. Harbor was born in 2000.
Yes,
Last 4 digits, social security number 6213.
yes.
63, okay. This is a motion for shock probation.
Your Honor, since Haley's been incarcerated, she's taking advantage of some of the programs there.
Which ones are?
She's she's got her GED now. She has a substance abuse program that she graduated from, and I believe today you graduated from a trauma program. Is that right, Haley?
Trauma, yes.
What do you have to say, Mr. Stockton?
I'm more interested in what she's gonna do if she gets out.
Do you have a job lined up?
Yes, I'm going to Tyson when I get out.
Where she's gonna live, she's got stable housing, her parents live in Indiana,
I do.
and she's not done very well here in Clinton County, so I wanna make sure she's got living in a good place.
You heard the question Commonwealth has, where are you gonna be residing and with whom here?
I'm gonna be staying with my mom's friend. Her name's Dolores Cecil. She lives in Monticello. That way I'm out of Albany, but close enough where I can still see my kids and,
You go to work.
Did you ask me something? I'm sorry.
Yeah, and you can, close enough, you can still go to work there too.
Yeah, yes.
December, so if I would like to have a condition that she be employed.
Okay. What we're gonna do, I'm gonna go ahead and shock probation, but you are to stay in close contact with probation and parole.
Yes.
And you need to be employed within 10 days from the day you're released.
Okay.
Okay, and so you have somebody come and get you, I'll let you out in the morning at 8 o'clock. Okay,
Yes, I do.
okay, don't let us down, Haley.
I won't. Thank you so much.
I don't usually comment, but you look much healthier than you did when I first saw you,
Thank you so much.
I hope you get where you can have a meaningful relationship with your children and have a.
Thank you. I appreciate it.
Okay, take it easy.
Haley,
Yeah.
soon as you get released tomorrow, since the person you're living with lives in Wayne County, then as soon as you get released, you need to come straight to the Monticello Probation and Parole.
I will. Thank you.
Okay. Tina Samson for sentencing. Are you Tina Samson?
Yes, sir.
You born in 1969?
Yes, sir.
The last 4 digits, social security number 8714.
Yes, sir.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason why she shouldn't be sentenced?
No, Your Honor.
Paul pleaded guilty to trafficking and controlled substance, first offense, C felony, 3 counts, and finish over C. 5 years to run concurrently for a total of 5 years, serve 120 days in jail, the balance probate for 5 years, finish or receive credit for time served. Now, what's something she got in there?
I'm sorry, sir.
How much time do you have in now?
I've been in since April the 20th.
How many days is she?
73 according to her PSI.
Yeah, you want her to serve the 120, Mr. Stockton?
Yes, it is.
Okay, so you have 120 minus 73. What are the court costs involved in this thing?
155.
Court costs $155. You can pay it $30 a month starting 30 days after you're released, okay?
Okay.
And your probation and parole officer will be over there to talk to you before you're released. Okay, thank you very much.
All right, thank you.
Yeah, Mickey Shelton,
Yes, sir.
Commonwealth versus Mickey Shelton. 24 CR 0085. You are Mickey Shelton. You were born in 1970, is that right?
Yes, sir.
Last 4 digits social security number are 7583. You have a pretrial conference. What's the Commonwealth had to say?
I don't know what to report on this case. We have another case, and I don't know if Mr. Shelton wants to try to settle it or if he wants to trial it.
Your Honor, I think he wants a different attorney, and I'm gonna accommodate him with that.
You gonna withdraw?
I'm going to get another attorney from the DPA to represent him.
Okay, August, he'll be here with a new attorney for negotiation day on August the first. Next court day is on August the seventh. Okay, now, I'm only negotiating on both the cases on that day.
Well, there's only one. He's got a 10-year sentence on one case. We did on the handgun. And then the one in danger will not try.
Okay.
And he got the 10-year sentence. So if he does want a trial date, I'd ask for the first of the year because he's not going anywhere.
Well, there's no reason to have a negotiation date.
No, not his attorney can contact me if they've got a proposal.
I'll let him know that.
I'll set it just so it won't slip under the rug here anywhere for November the sixth. Your new attorney will be over there within 2 weeks to talk to you. Yeah, that's motion day. No, he said he was gonna be a state prisoner. Well, I'm not gonna have him here because Mr.
Yeah, I don't want to, I won't be able to get this case to probably the first of the year anyway. If they're dry.
I don't want to set a trial date here because I think that they'll end up really good. Okay. And November sixth will allow us to set a trial date after the first of the year sometime. Your new attorney will be over to talk to you, sir.
You said November sixth.
Next court date is November the sixth. Unless the new attorney schedules an agreement to enter a plea of some sort, okay? Is there anybody, Russell County, y'all have anybody else over there that needs to talk to us?
Your Honor, we were informed that you all needed, Joey Duvall has asked though if he was supposed to be in court today to be released to drug court. But other than that.
Joey Duvall?
Mr. Cross is supposed to be coordinating that.
Do what?
He's being released next week for drug court.
Yeah, he's already coordinating, Mr. Cross.
He's gonna be released next week for drug court orientation.
All righty. Then
Okay,
that's all we
very much.
have.
Very much.
Thank you.
We never did hear from LaRue County or Taylor County, so right? Well, LaRue County was a motion of shock probation. In Taylor County was Brian Gross. What was the deal on Brian Gross?
He's the one that got 3 years that Miss Gordon Anderson tried on the possession. He still has another possession outstanding. And so I would ask that he be put on the 7th and the negotiation the 1st.
August the 1st and the 7th, and somebody needs to go visit him.
Yes, sir.
Okay.
This Wesley Stockton. It was on the docket for last month, didn't appear. It was discussed and believed that maybe he didn't get notice of the change of court date for June, so you didn't issue a warrant, you just said, hopefully we can issue the summons. And just set a date for today, for you to come in and explain why he wasn't here. He didn't show the negotiation that
He hadn't been
he
present.
wasn't in court to get the negotiation date.
He hasn't been present at the last two negotiations.
What's he charged with?
Cruelly and animal.
Issue bench warrant.
I think he knows enough that he should check with Mr. Rutherford when he should be doing.
I've tried to contact him.
Yeah, issue bench warrant, scheduling on August the 7th. Negotiation day on August 1st. Is there any other criminal matter come forward?
We have supported back if we want to do it.
Let's go off the record here for. Gotta come on camera. Be seated. Thank you very much. Okay, we got the DVO docket here. Stacy Byers Smith versus Robert Matthew Smith.
Your Honor, I represent Stacy Byers Smith.
I'm here about Mr. Smith, Crossville.
Yeah, y'all need to come up here to podium. Lawyers need to sit in the middle and your client on each side. Okay, you want to take some testimony in this case?
Yes, Your Honor.
I have a couple of pre-hearing motions as well. So the first motion is.
We'll move over this way and you need to speak up here.
So the first motion would address the fact that, since this EPO is sought on behalf of a juvenile, we are requesting that a guardian ad litem be appointed for the juvenile pursuant to Rule 17.03, also, pursuant to the holding in Yates, which I've got a specific citing.
You're gonna have to speak up.
Sure, yeah, I will. So also pursuant to the holding in Yates on behalf of EY versus Yates. Essentially, there the court held that whenever the interest of a minor are being addressed, this EPO seeking a protective order for the minor, I basically request that there be a guardian ad litem appointed. Given that this is a juvenile involved and that juvenile's interests are being impacted by this proceeding, they were entitled to have a guardian ad litem appointed.
Your Honor, I'm not aware that's required. I think that would be up to the judge.
If you looked at that.
I have not
case.
looked at that case, but I believe it
When
would
did you
be.
file these motions?
I'm just bringing them up now.
Hey, it's always good, to give opposing counsel some notice of what you're gonna do to the court. Jeez. Man. Yeah,
My response would be to that it would be in the court's discretion if the court hears the proof and feels that that is necessary.
I don't know whether that's what the case law says. You got the case with you, got the citation letter, pull it up and read it for a second. Sure.
Here it is. The citations up here.
You make that big.
Give us a citation. Give us a citation.
Yeah, so Yates is referencing Smith v. Doe. That would be citation 627 Southwest 3rd at 9:15.
How old is the child?
And Your Honor, kind of as a practical matter too, I don't want to go in too many different directions at once, but there is a divorce filed. Even with this EPO, I think there's going to be an issue of temporary custody and visitation as well. Of course, we've got to sort one before the other, but given that both issues are going to be at play, I was going to suggest that we maybe consider doing a hearing for both at the same time. That way, the information you're going to hear about the CPO is, I'm sure, going to relate in some way to custody and visitation. So just so we're hearing kind of everything all at once, and we can kind of get the most out of one hearing instead of like maybe multiple hearings.
It appears that case did require a GAL. But like I said, I had no notice of that. This case has been passed twice by Mr. Bell.
So I've been passed a single time by Mr. Bell. Whenever I appeared here for the original hearing, they told me that it was going to be moved to July 2nd because there is a divorce pending. So we weren't even able to be heard on the record to request the guardian ad litem at that point, which I would have done then.
No, I'm talking about the first time you filed a motion to pass it, and I didn't know until I came
Oh,
to
sorry,
court.
that is correct. The first one we had to move because by the time I was made aware of it, I'd already had appointments. They said I wasn't able to be here on that quarter. The second time it was moved,
They filed a divorce like 20 minutes before the hearing.
So the order of protection is in place now.
It is, Your Honor.
Well, if you want to continue it 6 months, it's fine with me. If order of protection is in place now, if you want to put it off.
Well, Your Honor, we're not putting it off for the sake of putting it off, but I'm just
Well,
afraid
I mean,
that.
whatever it is, if we get a guardian ad litem, it's gonna take some time. Who's next on the list? Let me see the list. Not everybody, can't hardly get anybody to take these cases anymore. Should get through this.
You know, as a practical matter, I would propose, of course, it's had to be by agreement, but as a practical matter, I would propose maybe a no contact order between these two parties. Let me set the matter for.
No, this is gonna stay in place till I hear it. Okay, with the allegations that are made in here, I don't know whether they're true or not, but they're serious and dangerous if they are. Until I have a hearing, this is gonna stay in place. And I will fully prepare to have a hearing today, you know, with whatever is necessary.
The way I read, I'm not looking at the Yates, but the way I read Smith versus Doe, he responded in the IPO as a minor child. And that required GML to be not a protected individual in the petition. Doe was a minor child. He was only 13, he was 13, and they was on the GML to represent him. And an IPO was issued against him.
So my position would be the child would have an interest in seeing both mother and father. This EPO.
Yeah, is that case say that?
I don't have the Yates citations, I'm not sure what Yates
So
says.
on Yates, that case is a little bit different from Doe. But essentially the EPO was granted for Mr. Yates. She gave temporary sole custody of the child. So in that, I would argue that the Yates
Well,
case.
what does it say though? I don't know what you would argue. I don't want to hear your argument. I want to know what the case said.
Okay.
Well,
So, I don't have the citation.
give us a citation on that
So
case.
Southwest, citation for the Yates case is 2024 WL 2484497.
Unreported.
It's unreported.
Correct.
It's not required, but what's requested is not. There's your virtual error.
Come here and show me who, just point out your information.
Some reason connection to the case. You know, just the next time, so you know, the link to the next second case. No, she accepted the last from the film, had one, so these are back on the doctor, so you get both back. So it's stuck back to that.
So. Oh. She go.
Yes.
So we're gonna try Jacqueline Sawyer's. If she can't take it, we'll try Jasmine King. Now, let's get your calendars out. Let's schedule this thing. We'll get,
Your Honor, may I step back here and get my phone with my calendar?
sure. Yeah. We'll be back here on August the 7th.
You know, would that be for hearing of issues?
Do it at the end of the docket on August the 7th.
Will the court, oppose, we file, provide notice and all this of a motion for temporary custody visitation? We want to try to do that on that day as well. Just so I guess kind of, she might have to hear everything potentially twice. Because.
I don't have any problem that the party stipulates that any evidence heard at that date would be considered in both county cases. I don't have any problem.
I think that would be okay with my client.
Yeah, be good.
We've
Okay.
not had a chance to get a response file. We plan to do that next week.
Okay, thank y'all very much.
Is that a regular motion day?
That is regular motion, right?
Y'all said it was very.
Still-
2 o'clock, where soon thereafter council might be heard, and we'll stay as long as necessary. Kelsey versus Kelsey.
Your Honor, we have withdrawn our motion and plan to refile.
Okay. Collins versus Baldwin.
Sir, motion for default, quite tied, Your Honor. We've tendered a judgment. I think everything's in order.
Let me see the petition in this case. 25 CI 00028. Rather than usual.
Yes, anytime there's a land contract drawn by a non-attorney, it usually ends up in a mess. And sometimes when the attorney does, it ends up.
Never placed a record. It was never placed, stay there.
No, it never
It was
was.
never placed a record.
Right. But fortunately, it may not be explained in there. The people that had the outstanding half interest, once we sued them, came in and made us a deed. So now we're just quieting all these other older liens and things.
And you're convinced that all these other lien holders were properly served?
Served through the law firm. Most of them are stale anyway. It's just a belt and suspenders thing. I'm finding most of these people don't contest. Thank you.
Compare those two lectures. Westlake Services versus EVA Westlake Finances versus Julie Duval.
Good afternoon, Your Honor. William Rich on behalf of the plaintiff. This is just a motion to transfer venue to Jefferson Circuit Court. The defendant now resides in Louisville. So we're just asking the court to transfer the matter to Jefferson County.
Well, reluctantly, I'll agree to transfer. I sure hate to take the case off my caseload. You make a compelling argument to me. I'll go ahead. We'll sign the order, okay, electronically. Thank you very much.
Thanks, Judge. Have a good day. Appreciate it.
Leslie Ketke versus Brian Connor. Ms. Coleman, the defendant is here. Who is your attorney?
Representing myself.
Oh, that's great. It's not a good idea to represent yourself.
Your Honor, the facts of this case are very simple.
Well, I don't want to talk about the facts yet. She's got a motion here, I guess. We'll hear that and then you can respond, okay? You want to bring your motion?
Yes, Judge, it's pretty straightforward. We've just filed a motion asking the court to schedule this for a bench trial. I don't think the facts are in dispute in this, so I think it was a simple, straightforward matter that the court themselves can hear without the need for a jury. Mr. Connor did reach out to me. I responded to him to let him know that my client's not currently in town, so I couldn't really discuss any sort of settlement with him. I'm open to doing that if we want to do that at a later date, but I can't do that right now. So I would prefer to go ahead and get a date. I know my client would like to get this resolved as quickly as possible.
I can't hear.
Okay. He was having trouble hearing because of the acoustics in here, so, which I understand. Okay, I read the petition in the case alleges that the defendant had a life estate and some property and your client's for the remainderment. Is that correct?
Correct, Judge.
Okay, and there was some timber cut off of it, and what else was done?
Yes, sir.
Okay, well, what relief do you want?
I'm not really.
What are the issues that would go to trial?
I'm sorry?
What are the issues to try? The value of it, is that what it is?
I would say the value. I think that right now my client would like a determination of whether whether there's been a breakdown between the parties to the point and actions enough that would warrant her seeking to dissolve his life estate, that sort of thing.
Okay, what do you have to say now, Mr.
The only
Connor?
amount of timber that was sold off of that is $3,564.46.
Yeah, well, as a life estate owner, do you feel like you have a right to cut any timber on it? Is that your position?
Your Honor, I thought I did. I would
No,
never.
I think you're wrong.
Well, I'm sorry, I made
Yeah.
a mistake.
Yeah.
I was wrong.
Yeah, and you know, a life interest owner can harvest crops and do those sort of things, but my understanding is timbers is just like a house or anything else is a part of the land, and you can't. Is that your position, Ms. Coleman?
Yes, sir, Judge. It would be that he was obviously taking resources off the property without the permission of the remainderman.
Yeah. Okay, so he claims that so the only issue then is the value of the timber that has been taken. Do you have a timber cruiser that's looked at the timber, Ms. Coleman?
I'm sorry?
You have a timber cruiser that has looked at the timber to see what you estimate the value of it is?
Well, I know my client has spoken with the individuals that Mr. Connor had contracted with. So I think that would be the person that we would be looking to provide to the court the amount that it damaged the property.
Well, I'm going to just, at this time, advise Mr. Connor not to take any more timber off of it, okay? Okay, and I want you to get an order on that, and I'm gonna give you till the next rule day to come up with some estimates of damage on the property, okay? So you need, Ms. Coleman, you need to be the one that allege, I'm not gonna have a trial on this thing before we have a timber estimate or something. And maybe you can come to an accord on the thing. Now, do you believe that a life estate owner, the value of a life estate owner would diminish the judgment that you would be entitled to? Ms. Coleman?
I'm sorry. I'm very sorry. I don't know if I have a bad connection. I'm having a really hard time hearing, and I apologize.
Well, maybe it's me. Here's the point. If somebody has a life estate in a piece of property, they have some numerical interest in any proceeds. For example, if they agreed to sell the timber off of it, there would be a life estate table and they would calculate the amount that the life estate owner would have in the remainder. Do you agree with that as a principle?
Yeah, if all the parties had agreed to do that and they felt like that was in the best interest of everyone involved, sure.
They haven't agreed to that. So but that doesn't diminish the fact that the life estate owner has some interest that he should be able to receive, even if it was wrongfully taken, in the value of the timber.
And we would argue against that, Judge, and I would just need to submit a brief, I guess, to that effect, because the timber, the entire acreage is not.
I don't need for you to argue it. I was just finding out what your position was. Now, you're saying he has no interest in any value of any timber that was taken over there. It's a timber trespass. Is that correct?
Correct.
Okay. And so you would be entitled to triple damages on a timber trespass. Is that your position?
Yes, sir.
Okay. Do you have any case law on that?
Not at this time. Like I said, I'd be happy to submit a brief if the court wants me to do that.
You need to get a lawyer. Okay. Okay. So I'll give you 20 days to get a lawyer. And our rule day here is not till August the 7th. And I want you to have a lawyer and file an answer within 20 days from today. And if you will go ahead and brief your position on the law to me and serve it on Mr. Connor, and Mr. Connor can take it to his lawyer.
Yes, sir.
I'll also serve on us the same you would if you'd had to do interrogatories, what the value of the timber that was taken is, and how you're justifying that valuation that you've come to, whether it be the person that bought it or whether you want to do a timber cruiser or whatever, okay?
Yes, sir.
You can do that within 20 days also.
Okay.
Okay, well, thank you. Yes, Mr. Connor.
Yes.
Do I need to issue an order resetting this for the August rule day, or will the court do that?
Yes, go ahead and reset it. Mr. Connor has something. Speak up, Mr. Connor.
Yes, I've been trying to reach their office since before last court date to try and settle if they would just give me something that we could.
Well, that's
settle.
what she's fixing to do. She's fixing to give you an amount that they feel like the timber is worth, and the law that says that you're not entitled to any of it, even if it's wrongfully taken. That's the reason you're gonna need a lawyer. But you think there's just been $30-something hundred worth of timber taken off.
Correct.
Is that correct?
Yeah, that's correct.
That's what you've received.
Yeah.
Is that what you've received, $30-something hundred?
I got an advance for $8,000 on the crop, and I'm still owing the difference.
What do you mean on the crop? You talking about on the timber?
On the timber, yeah.
So
$3,564 is what they cut, so.
Well, that would be what they cut.
Yeah.
Okay, so that's the only thing. She doesn't care how much you got paid for all of it. She just cares how much has been cut. Is that right, Ms. Coleman?
Yes, sir.
Okay, so we'll see if you can come to some arrangement on how much it's cut. And if she gives you that amount, you might go to the lawyer and say, well, I want to hire you, but I want to wait till I get from her how much they claim it is. And also the lawyer will need to look to see if she's entitled on a timber trespass to 3 times the value of the timber plus attorney's fees, which you can get on a timber trespass if you can prove certain facts. There'd be certain facts you'd have to prove on that. It was, and this is unusual circumstance, so I'll give you both those times. Would you draw an order, Ms. Coleman, send it to me, and And I'll send it and also serve it on Mr. Connor, and he can take that proposed order to his attorney and they can look at it, okay?
Yes, sir.
Okay, thank you very much.
Thank you. Maybe I'll be excused, Judge.
Absolutely, thank you. Spear versus Elmore. Okay. Now, who are these parties here?
Your Honor, I represent Scotty Spear, the father of the two.
Is that him there?
Yes, sir.
Okay, and who are these other two ladies?
The maternal grandmother and the mother.
So we got the father and the mother here, and she didn't appear last time,
Correct.
and I entered an order granting him custody.
Correct.
Why didn't you come back? Why didn't you appear last time?
I was sick.
Okay.
Hold on. He supposedly supposed to put the order
Well, you
in.
know, but just calling in and saying you're sick is not enough, because if you
I
do
was-
that.
I was throwing up.
Well, I'm not doubting you were sick. I'm believing you, but the bottom line of it is we can't just allow people to call in and say they're sick without coming in here and, you know, going under oath and that sort of thing. Now, what was the custody order that I entered temporarily?
Basically, custody to Scotty, parenting time at his discretion.
Yeah.
And that's what we would request that we
Well,
continue.
I'm gonna take proof today from both of them, okay? And why, you don't have a lawyer? Why don't you have a lawyer?
I couldn't afford one.
You what?
I couldn't afford one.
Did you talk to any lawyers to determine whether you could afford one or not?
I don't have, that's the thing. I had breast cancer. And there just, I couldn't afford one.
Okay, well, let's go ahead and we'll let Mr. Cross put his evidence on first.
Your Honor, I requested that Melissa have them bring over a criminal case involving Miss Elmore. They'll have.
Well, you can testify to that. We can bring it over here. Y'all have a seat over at that table over there. No, that one over there.
And I'm gonna call Miss Elmore first, the mother. Absolutely.
Y'all can both sit over there at that table.
I'm calling her.
He's gonna call her as a witness now. He's gonna call her as a witness. Yeah.
No, she can't get her words out, Your Honor, that because she had a pin stroke.
We'll see.
What just me?
Can you raise your right hand? You swear the testimony you're about to give is the truth, the whole truth, nothing but the truth. Have a seat there and lean toward the microphone. That red thing, and let me hear you say real loud your name, okay?
Kimberly Elmore.
Okay.
Miss Elmore, you have recently been evicted from an apartment, is that correct?
Yeah.
How many children are involved?
Two.
Okay, well, let's get some facts on here before we
Okay.
start, just go straight to the slurs.
Well, okay, I understand. Are you and Scotty have two children, is that correct? Need to speak up and say yes or no, ma'am. Okay. You need to speak up and say yes or no.
Yes.
Okay. What are their names and ages?
Adley Dean Elmore, or Spear. She's 4, and Easton Spear is 2,
4 and
or 4 and 8.
4 and 8.
You're 4 and 8 years old?
Yes.
Yeah.
You and Scotty never were married, is that correct?
No.
Okay. And when have you last had physical custody of these kids?
We came into court on, it was involving, the case.
Which case? Is this the criminal case against you or was it a juvenile petition?
No, it was both cases.
Was it in district court, down in district court?
Yeah, it's Loveless.
It wasn't?
It's Loveless. Or no,
No.
Lawson.
Okay.
Yes. Why were you in district court, Miss Elmore?
The cases.
Were you accused of abandonment of these two kids?
No, I wasn't.
I didn't ask if you said you were guilty. I need to get the court file, Your Honor. I don't know why they haven't got it up to you. I'm sorry. Okay. Would you, oh, Melissa's got it here. Thank you. Miss Elmore. There was a criminal complaint taken against you on April 20th of this year by Officer Parker Hickman. Wrote the citation, and he says, received a call that Miss Elmore had left her apartment with her two children still inside and had been gone for at least 30 minutes. The older child had left the apartment and went to the neighbor's apartment and told the neighbor that her mom had left her and her sister in the apartment alone, and that her 4-year-old sister was still in the apartment asleep. When I arrived on scene, Ms. Elmore was back in her apartment with only the 4-year-old. Ms. Elmore states that she had been to the next door building. Ms. Elmore.
Well, here's the thing about it. How can she cross-examine this officer?
I'm just gonna.
Well, I mean, you're presenting that as evidence. You know, I think the point is that they charge her with abandonment, your point.
It's abandonment of a minor 2 counts, and attempted abandonment of a minor 2 counts. A felony. Yeah, and I want to get a copy of this in the record. Okay.
I don't know about that. I'll decide later about that, whether it's admissible or correct. Go ahead.
So the court removed these kids from you, didn't they?
No, they didn't. They did not.
Okay. Well, Debbie ended up with them, didn't she?
No, because I was moving. Because I was moving.
Okay. Well,
Because what?
Because I was moving.
Speak into the microphone.
Because I was moving.
Who is Debbie?
Her mother.
Okay.
How long have you lived in the apartment that you just got evicted from?
October.
Of last year?
No.
Okay. And you said you were moving. Were you moving back when this incident came up?
Do what now?
Were you moving from that apartment back in April when you got these criminal charges against you?
No, it wasn't.
Okay, so,
Because I was evicted.
sorry, the door closed. What did you say?
Because I was evicted.
Because you were what?
I was evicted.
Okay. Do you know why you were evicted?
Because that case right there.
Because of this. Okay, okay. So Scotty's got the kids now, correct?
Mhm.
How long has Scotty had the kids?
Since we came into court last time.
That's the district court over this case, correct? This case I've got in my hand, not the one we're here on today, correct?
No, no. You come into court on it's whatever day, July or no, May of. I don't know, what was it, Mom?
I don't know. Can you pass, ma'am, if you take a drug test today, could you pass it?
Yes.
Wait, just you get a chance to testify.
Who delivered the kids to Scotty and when?
My mother did, because I was on house arrest.
Okay, and that was that after we filed this petition?
Look, she doesn't know the difference between district court and circuit court petitions or that sort of stuff. Did he, when you came to court last time and she didn't show up, You have the children already then?
He did.
Okay.
I'm trying to
Okay, well,
pinpoint that.
that's the way to act, that, you know, it's like when the snow was, okay? So when you couldn't come to court last time, your father, the children already had them. How long had he had them?
It was. I don't know. It was days, like.
Okay,
a
and
couple of days.
how did they come, how did he have them? Did you give them to him?
Yeah,
Was that because the court told you to?
no,
No, so were you sick or why did you give him? Just for visitation or why did you give him the children on that day?
I was sick one day, I just.
So the answer is she delivered the children to him.
They did.
Okay. And
Yes.
he's had them then, and you filed this then.
I filed this and then they delivered the children after they got served. It's my understanding.
So what she says.
I know, but where are you living now, Miss Elmore?
I'm living in, I'm between homes.
You don't know?
I'm between homes.
Okay, well, that would be between where? Where is your goal? Where do you think you'll be living?
I don't know.
Okay. Okay. Do you have anywhere to go other than your mother's?
No, but that's my problem.
Okay.
You see, the one down below you,
Yes, ma'am. The one that's, as I
that,
characterized. being-
that is not my home. That is not our home. That is nobody's home. And, okay, so,
So you
anyway.
said there's nobody home, there's your mother's
No.
not living there?
What?
Who's living
You
there?
cannot bet, you're gonna have to slow down here.
Well,
Okay, here,
she's not making any
wait just
sense.
a sec. Well, I understand that. But you don't have to say that. I mean, she's struggling. Okay. I am going to stop this hearing and appoint her a guardian ad litem. I do not think she's capable of answering questions without advice of an attorney. And I don't know who will pay for that or whatever, but I'll try to find some way. I think that there's a situation because she cannot answer the questions that you have. So I'm gonna go down the list and get somebody to meet with her. Maybe they need to call Apple Red or somebody. I mean, this is a serious matter when you're talking about the custody of these children. And what's your client's position now, Mr. Cross, as far as her having visitation with?
Well, he doesn't want her to have any visitation at her mother's because of the condition of that place. Any visitation ought to be supervised by someone and.
Wait a second, wait a second. Okay, I'm trying to help you. He's just saying what his position is, okay?
No, until she has a home and gets stabilized, this discretionary
Okay,
thing.
well, tell me about her mother's place. There's your mother sitting right there.
You want to drive down there and look at it? It's unfit for
No.
human habitation.
Wait, what, you just be quiet. Okay, what are you saying?
I'm saying it's unfit for human habitation.
But that's not the home. That's not home.
Okay, where is the home? Where do you live now?
Uh,
Where's your mother live?
Currently, he's at, brother's.
Who is? Your mother is? Okay, no.
No.
You just be quiet. Just be quiet. Are you the mother?
Yes.
Okay, where are you living now, ma'am?
I am living with my brother and sister-in-law, but I've got an apartment. I'm moving into it right now. And that's where I've not stayed at my house since my husband passed away. And that's been over a year ago.
Okay, you can.
You don't know what you're
Wait just a second. Wait just a second. You can go back there, ma'am. I want you to come up. Yeah, I also need a guardian ad litem appointed for the two children.
Yes.
I want a guardian ad litem appointed for the two children. You know, I guess, I don't know whether I can appoint one for her or not. I don't know what the provisions are. But she needs somebody. She'll need Apple Red or someone, so I want you to give her the clerk's office to call Applewood, okay? Okay, so what we're trying to do is get you a lawyer and get guardians for the children, okay? Now, raise your right hand, ma'am. You swear the testimony you're about to give is the truth, the whole truth, and nothing but.
Yes, I do.
Okay. Now, you live in the residence you previously lived in before your husband died is the place of.
Yes, I do, but it's what.
Wait,
I'm sorry.
you don't, you just
Yeah,
wait to
I'm sorry.
question, so,
I'm sorry.
okay, I'll get real, I'm trying to
I
do the
guess.
right thing.
I know, but I'm
Okay,
sorry.
Be quiet. Now, the resident where your husband and you used to live, he passed away and you say that you have not lived there since then, is that correct?
Not correct.
Okay, and you're living where now?
Staying at his sister and brother's house on 1116 Shelter Street.
Your sister-in-law and
Brother-in-law, my
brother.
husband's brother.
And you're
sister.
living there with them.
Mhm.
Is your daughter living there now too?
No,
Where is she living?
she's gonna be moving to.
No, I didn't ask you
Oh.
where she was gonna be moving.
Oh, she lives, she's just now being evicted from.
No, I didn't ask you where she's been evicted from.
She's still staying over there at that apartment,
The apartment that she's been evicted,
Yeah.
and how much longer can she stay there?
just today.
Just today, and where's she gonna go?
She's gonna go to 131 Craig Street, hopefully.
What is, well, I'm not talking about hope.
Oh, I'm saying, yeah,
Okay,
I'm
well, what
sorry.
is 131 Craig Street?
it was my mom and dad's place.
Okay, do you know where that is, Mr. Cross?
I do.
Is it a fit place for her to live? Is there electricity and water there?
Well, that, I got the water, that actually,
I didn't ask you
Yeah,
what you were
no,
gonna
not
do.
yet.
Well, so she's gonna move someplace that doesn't have electricity or water. Do what?
I just got to turn it on.
When?
I go today.
No, you can go, but I'm not talking about what you, okay, you go on and sit down back over there. I'm not gonna get any help out of you. Like I said, it's going to sit down.
I'm
back.
just trying to.
Go on and sit down. Go on back over there and sit.
Today.
Okay, it's okay. Okay, I'm gonna appoint a guardian ad litem for the children. And they're to call Applewood to get her a lawyer. She needs a lawyer. Okay. And because I'm not sure that that she's confident to understand the proceedings, and I'm not going, so I'm gonna continue this case until August the 7th.
It's fine, Your Honor.
Okay, now,
Status quo.
as far as visitation is concerned, what would your client propose about letting her see these children, so? Until we get to see.
We would request, Your Honor, the order that's in effect remain in place.
Well, what does it do? Remind me what.
That is, that it's purely in his discretion.
Okay, well, I'm gonna try to set some structure up too, because they're not able to communicate with each other. Okay? Is there someplace that is that his mother here? Is it?
Yes.
Yeah. Do you get along with his mother all right, ma'am?
I did.
Okay, well, let's see if we could set some visitation up with his mother. Is that all right with you, ma'am?
I'm fine with that, but actually, I live in Jamestown, Tennessee. When my son comes to visit me with the kids,
Okay, well, it won't
like
work.
every other weekend,
it-
at work, I'm good.
Okay, it won't work. I thought you lived here, okay. You have any place to suggest where she can visit with the children?
I just think, and Scotty's in Russellville working, they're still in Russellville.
Well, where are the children staying?
With him. They're with
In
him.
Russellville, Kentucky? Who takes care of the children while you're in Russellville?
My girlfriend.
Your girlfriend? Yeah. How long have you been with this girlfriend?
7 months.
Yeah, so you've taken the children and left with them. You left, the children aren't in Clinton County anymore.
No.
Jeez. Well, I think social services ought to be notified some too. Okay, to let them go check it. Ma'am, you can't raise your hand and say anything. Mr. Cross, you want to go back and talk to your client's mother for a second? Well,
Your Honor, humbly suggest that it remains status quo. Let's get these people
I'm
appointed.
gonna
Get
keep
her,
it status quo, but I'm trying to figure out some way this woman can have some contact with her children. But let's see, let's wait. Let's wait until she gets a lawyer and see what, there's no place here in town. Yeah, well, your clients want to say something.
yes, Scott.
I make sure I ain't trying to keep the case from.
Speak up so we can hear you.
Talk to your attorney
Yeah,
first.
I'm not trying to keep the case from one. I make sure that they say them every other week, if not every week.
May he come up and speak?
He can speak, I can hear him there.
Okay.
So you're by agreement willing to make sure that she gets to see the children every week?
Yeah, I keep them updated and I make sure they talk.
No, I'm talking
them.
about her seeing the children.
Just about, you know, just about every week, if not, it's every other week for sure that they come down and see them.
They come to Russellville?
I come down here, I bring them down here, that way
You
they
bring
can
them
spend
over
time
here
with
to-
them. Yes, sir.
And where do you bring them to here?
Hayes, where Debbie lives.
Yeah.
And Kay would be a regular person. That's no issue with that.
Well, why don't you bring them over here? You usually come on Saturdays or what day you usually come on?
Yeah, Friday or Saturday.
Okay, well, until we get this resolved, you bring these children over here, 3 hours, either on Friday or Saturday. Every week, till we get this resolved, okay?
Yes, sir.
And that'll let the mother visit the children and they keep to know her and the grandmother can be there because that's her sister-in-law and stuff. And then we'll try to get Apple Red involved in the thing and guardian ad litem for the 2 children. That's the best I can do.
Thank you, Your Honor. I'll go over the drawn order. So
Now,
we
do you
don't-
understand? Look, young lady, here's the deal. Here's the deal. I don't think that you're capable of representing yourself. You need help. Okay, so I'm gonna call Apple Red or clerk's office to see if they'll come and represent you. I'm appointing another attorney to represent the interest of the children. That attorney will interview the children and that sort of thing. But until then, he's gonna have to bring these children over here either a Friday or Saturday every week so you can visit with them for 3 hours. Okay, so you keep in contact. That's the best I can do right now. Okay, thank y'all very much.
Oh,